All right, appearances on Huron versus Lowry.
Good afternoon, Your Honor. William Mays on behalf of Mr. Lowry. Mr. Lowry, state your name, please.
Scott Lowry.
And seat.
Have a seat. Have a seat. All right, are we ready?
We are.
All right. I've read the pleadings. Hit the high points. Add anything you want to add. However you want to do it.
I thought we were just going to do an evidentiary hearing.
Did you read a response?
Response?
Yeah, she filed a response that said we didn't need an evidentiary hearing.
I thought that we argued that already.
Did we argue that?
Yeah.
Kind of touched on it and it was set for an evidentiary.
Yeah, that's what we set it for
All
today.
right, put somebody on the stand then.
Yeah.
Who do you want to have?
Officer Sensei?
Say your name.
Officer
Sazai. I can't get
Wasn't
that.
making it up.
I can't get that out of that spelling. It just throws me every time. Come on. Watch your step on the ramp. Raise your right hand as you approach. Swear affirm, tell the truth, the whole truth, nothing but the truth today.
I do.
Settle in.
And then your way, that's going to be
No.
Thank you.
When you're ready.
Name for the record.
Officer Sansai
How are you employed?
with the Huron Township Police Department.
And how long have you been with the department?
Year and a half.
And in that time, if you had to estimate about how many OWI arrests you completed?
At that time, I would say approximately 4,
And how about now?
over a dozen.
And were you on duty on September 15th of last year, just after midnight?
Yes, ma'am.
And around that time, were you dispatched somewhere?
Yes, ma'am.
Judge, I'd ask that we sequester any witnesses. I don't know.
Any objection?
No objection.
Step on the hallway. We'll get you back in if we need you. Thank you. Proceed. Thanks,
Where were
Heather.
you dispatched?
I was dispatched to 33875 Stedman Road.
Is that here in Township?
Yes, ma'am.
Do you recall why you were dispatched to that location?
For a welfare check.
And about how long were you there investigating the welfare check? If you had to estimate.
Estimate probably about 45 minutes.
And during that time, did you make contact with the defendant?
I did.
And did you know the defendant prior to this incident?
No, ma'am.
Do you see him in the courtroom today?
Yes, ma'am.
Could you identify something that he's wearing for the court?
He's wearing the black shirt right there.
Noted.
And glasses.
Thank you, Your Honor. And at that time, was the defendant under suspicion of operating while intoxicated?
At that time, no.
Was he under investigation for any reason?
For breaking into the house and
Well, at the time that
At
you
the time?
initially,
no, ma'am.
in fact, you were just there for a welfare check.
Yes, ma'am.
And did you and the other officers eventually ensure that the homeowner's welfare was okay?
We didn't see her per se. She stated she was okay through the enclosed door inside the residence.
Perfect. And at that time, did you clear the scene?
Yes, ma'am.
Did something prevent you from leaving the location?
Yes, ma'am. The female started shouting out through the residence, through the window, I believe, and she was accusing or stating that Mr. Lowry was intoxicated and he was behind the wheel at that time. And she also stated that Mr. Lowry broke into her residence.
And what was the defendant doing at that time when she stated those things?
He was behind the wheel on Stedman Road at that time.
Was the car running?
Yes, ma'am.
Did you see him operate the vehicle?
Yes, ma'am.
And did you approach the defendant to investigate the homeowner's claims?
Yes, ma'am.
Did you ask the defendant whether he lived at that address?
Yes, ma'am.
Did he live there?
Not at the time.
Did you ask him whether he broke into the home?
Yes, he stated his son let him in. After I asked him that question, he also said that he kicked in one of the doors at the residence to make sure his wife was okay.
And did you ask the defendant whether he had been drinking?
When I approached his vehicle,
Yes.
yes, ma'am.
What did he tell you?
At first, he stated no.
And did you believe the defendant when he stated that he was telling you no?
No, ma'am.
Why?
He had the smell of intoxicants emitting from his person.
And based on that observation, did you begin an OWI investigation?
Yes, ma'am.
Your Honor, this is where I would normally go into field sobrieties, but I believe the part at issue is the actual probable cause for the stop or the investigation.
Yep.
So I can proceed if the court wants me to, but I don't think
Any
it's
feeling,
necessary.
Mr. Mays, one way or the other?
I mean, in order to make it easy, we can break it up. So,
I don't care one way or the other.
Yeah.
I'm quick enough on my feet. I'll keep up with you.
okay. Whatever your pleasure is.
I mean, I don't think it's necessary if the only stop at issue is the stop
Okay.
itself.
Okay.
So, officer, when did you get the dispatch call?
At what time?
Yes.
At about midnight.
Okay, and what time did you arrive?
Time did I arrive? I don't recall. I would have to say probably in about 10 to 15 minutes if I'm estimating.
Okay, how long were you on scene?
Again, if I'm estimating, I don't know the exact time. Approximately 45 minutes for the welfare check.
Okay. When you arrived on the scene, well, did you mark down a stop time of Mr. Lowry's vehicle?
What do you mean by that? I'm sorry.
What time did you stop him?
I didn't stop him. I approached his car on scene after we initially cleared, and those accusations were being made by the female, stating that he was intoxicated, and at that point he was behind the wheel.
Okay, let me stop you. You arrive on the scene with how many other officers?
At first, it was me and another officer.
So just two.
Correct. At
Who?
first,
Who was that other officer?
Officer Nolly.
Okay, and then eventually other officers showed up.
Yes, sir.
So you and this other officer were the first two on scene.
Correct.
And the reason why you had been dispatched there, you said it was a welfare check, right?
Correct.
But to be more specific, a woman had locked herself inside of a bathroom, was breaking things around the house. The husband, who doesn't live there, and her two adult children were concerned about her mental state. Fair?
Correct.
She was acting crazy. Fair?
Correct.
Objection, the relevance.
Well, it goes to the credibility of the witness later on.
I'll allow it.
What's this woman's name?
I believe the first name was Heather.
Heather. Heather, I think it was Melton. Is that right?
Now, can I?
You can
can I
check.
look?
Yeah, absolutely.
Yes, sir.
Okay, so Ms. Melton is hysterical, yes?
She was yelling at us through the enclosed door that she didn't want to speak to us, stated she had possible weapons in the bedroom.
I'm sorry, she had weapons in the bedroom?
Possible weapons, correct, sir.
So did you take that as a threat?
It did arise a concern for safety for me and the other officer on scene and Mr. Laurie at the time.
Right, okay. So, and I'm assuming you've been called to situations where there's a mental health crisis before, correct?
Correct.
And the primary concern there, I mean, number one rule, of course, is officer safety, right? Yes?
Correct. Sorry.
Okay. And you want to make sure that the subject of the investigation doesn't pose a risk of harm to him or herself or others, correct?
That is correct.
Okay. And so whether or not she was suicidal, homicidal, or just having a bad day was the purpose of your being there, yes?
Correct.
Okay. She refused to allow you to have any face-to-face contact with her, correct?
Correct.
You were able to interview the two adult children?
Yes, sir.
And do you recall what their names are?
Objection, again, I don't see how this is relevant.
Mr. Mays?
It goes to the totality of the investigation, the totality of circumstances, Judge.
But the investigation was asked to when they approached Mr. Lowry's vehicle, not the prior investigation for the reason that they were initially there.
Response?
This stop is all premised on the credibility of one person making an allegation, that is Ms. Melton. So I need to know what the situation was around Ms. Melton, and then what the details of the investigation revealed as to whether or not she's a credible informant, I guess.
I'll allow it.
Thank you. You interviewed the 2 adult children, right?
Yes, sir.
Did you interview them together or separately?
I believe there were separate interviews.
Face to face, right?
Correct.
They expressed to you that they were concerned about her mental health, as to whether or not she might be suicidal. She's breaking things around the house. Both of them were in unison about that, correct?
Correct.
And you had an opportunity to interview Mr. Lowry there, correct?
Briefly, the other officer initially spoke with him.
Other officer, okay, all right, but you did have face-to-face contact with Mr. Lowry at that time, right?
I did.
And he again expressed exact same concerns, was that she was having a mental health crisis, might be suicidal, was breaking things, and they were concerned about her well-being, correct?
Correct.
At that time, did you failed to note any odor of intoxicants on Mr. Lowry's person, correct?
I wasn't really concerned
Okay.
at that point.
You indicated on direct examination that you'd been trained and that you've done a number of drunk driving investigations, correct?
As of right now, yes, sir.
Okay. You've taken the NHTSA course, the standardized field sobriety training course.
Yes, sir.
All right. You were trained that in that face-to-face contact phase 2, that there's a number of signs and symptoms that you should note to determine whether or not a person may have consumed alcoholic beverages before before they had contact with you, correct?
Well, the officer already testified that the purpose of talking to the defendant at the time wasn't as it relates to the alcohol consumption.
Well, I guess, is the prosecutor suggesting that the signs of consumption spontaneously appeared after this? And that they weren't present during the 45 minutes that the officers were in contact with Mr. Lowry?
He already asked and answered that he was briefly talking to the defendant, that he didn't exhibit anything because he wasn't investigating him for the purpose of alcohol consumption.
Or anything else at that point.
Right.
Well, I think that it still goes to whether the officer's training and experience and qualifications.
I think it's fair ground to ask him what his observations
Thank
were
you.
during that initial
Yeah.
contact, but keeping in mind that his focus was not on Mr. Lowry at that.
Understood.
Go ahead.
Yes, thank you. So, officer, you were trained that you're supposed to use your sense of sight, hearing, and smell to determine whether or not a person may have consumed alcoholic beverages before you have personal contact with them, correct?
Correct.
You're trained to look for bloodshot eyes, soiled clothing, fumbling fingers, alcohol containers, drugs, drug paraphernalia, bumps, bruises, scratches, and unusual actions by the subject, correct?
I'm gonna object again. I don't see the relevance in the initial contact.
I'm hoping he ties it up quickly,
I will.
so I'll allow it.
Okay.
Yes, sir.
You were trained to listen for slurred speech and admission of drinking, inconsistent responses, unusual statements, abusive language, or anything else, correct?
Yes, sir.
And you were trained to smell for the odor of an alcoholic beverage, marijuana, cover-up odors, or unusual odors, correct?
That is correct.
Now, during your initial contact with Mr. Lowry, you did not even detect, as you indicated, the odor of an intoxicant amongst his person, correct?
As I stated, I briefly spoke with him. He escorted me into the residence. I followed him.
Okay.
At that point, we made contact with Heather through the door, and she was shouting that she had weapons in the room and possibly wanted to harm others. So at that point, I had myself and the other officer had the defendant step outside the residence while we proceeded our
Okay.
investigation.
In this face-to-face contact, although limited with Mr. Lowry at this time, you did not detect slurred speech, correct?
No, sir, it was very brief.
And there was nothing during the personal contact phase that you made right there that would suggest to you that Mr. Lowry was in fact intoxicated, correct?
Could you repeat that? I'm sorry.
There was nothing in that interaction that you had with Mr. Lowry at that stage that would indicate to you that he was maybe intoxicated, correct?
I wasn't investigating that at that point, so
Okay.
it didn't slip my mind.
So then you go back to Ms. Melton and you focus your investigation on her, correct?
That is correct.
All 3 people were uniform in explaining to you that she had closed herself in that room and that none of them had any contact with her, correct?
Correct.
Okay. You had to speak to her through the door the entire time, correct?
Correct.
You never actually made face-to-face contact with her until you'd exited the home, correct?
And not once I didn't make face-to-face contact with her at all on scene.
Never.
Never.
Okay. So you just continued to talk to her through the door?
Yes, sir.
How were you assured, given the facts and circumstances surrounding this case, that she didn't pose a risk of harm to herself or others?
We asked Mr. Laurie on scene if there were any weapons in the house, which he stated there isn't.
Okay.
We also asked her numerous times to ask her about her welfare, if she needed any medical assistance, which she denied. Us being there made her more irate. And at the time, she didn't need any of our assistance or any medical attention. So we ended up clearing the call.
So the mere fact that your presence there disturbed her more is what you're suggesting?
She did not want
I'm
to.
gonna object, that's an assumption based on something that isn't here.
No, I think it's a clarification.
She did not want to communicate with us, and she did not want to exit the bedroom at that point.
Okay. Did you get the impression that she might be under the influence of alcohol or controlled substances?
I have no clue, sir.
Okay, all right. So you cleared the scene about 45 minutes later, right?
Approximately. Yeah.
During this entire time, you've had an opportunity to observe Mr. Lowry walking around and interacting with other people, correct?
Majority of the time on that call, I was in the residence in the hallway with my partner,
Yeah.
waiting for the other two officers to arrive
Okay.
on scene.
You had never met Ms. Melton before, correct?
No, sir. I have never met her.
She had no known credibility in your history with her, obviously.
This was my first time
Okay.
encountering her.
So she adamantly refuses there for 45 minutes to exit that doorway. And as soon as you clear the house, she bursts through the front door and starts screaming out profanities, claiming that Mr. Lowry is intoxicated and that he broke into her house. Yes?
I'm not sure if she exited the residence or not, but she was screaming that either through the window or through the front door of the porch.
Okay, all right. There was no reason to believe that any of her allegations were credible, correct?
She made allegations and I went to investigate those allegations if they were true or not.
Okay. You stopped Mr. Lowry's vehicle by activating your overhead lights, correct?
That's incorrect.
Give me just a moment, please. Did someone else stop Mr. Lowry's vehicle?
I stopped. I walked up to his vehicle. We proceeded to back the vehicle out of the driveway onto Stedman Road. At that point, Heather was making those allegations of him breaking into the house and consuming alcoholic beverages. So I walked up to his vehicle and proceeded with my investigation.
Okay. Oh, here we go. Sorry. Let me pull up mine. I'm so sorry, Judge.
Paper's so much quicker sometimes.
I know. That's why I turned to. Okay. You approached his vehicle and requested that he submit to a preliminary breath test, correct?
That is correct.
Okay.
My main focus was at that time, I didn't want Mr. Laurie driving behind the wheel based on what I smelt when I approached the car and started questioning him about breaking into the residence. I wanted to make sure that he was okay to drive back home.
Yeah,
That was,
but here's, okay. Was there any evidence that he had broken into the home?
Heather stating that he broke into the house. That's
Again, Heather is not a credible source of information, correct? She's threatening you with weapons. She seems to appear to be a risk of harm to herself or others. She refuses to open the door and she refuses to have contact with you until 45 minutes later, you're leaving the scene, right?
that is correct.
Okay. So her credibility did not go up instantaneously just because she made an allegation against someone else, correct?
Despite if the way she was acting towards us, I don't understand. I don't know how that would make her not credible at that time. Maybe she just doesn't like us. I don't understand how that would make somebody not credible.
Okay. You actually ordered Mr. Lowry to exit his vehicle, correct?
Yes, sir.
And what was the reason for ordering him to exit his vehicle?
Based on the intoxicants that I was smelling,
Okay,
him driving the
Wasn't
vehicle.
our focus on the actual probable cause or?
I'm on paragraph
something
19 of my
for the
motion.
stop?
I'm on paragraph 19 of the motion.
I could have continued with the actual OWI investigation.
Okay.
and had that done with time.
Anything else that's probable cause of this time?
For the stop? No.
Correct.
I
Okay.
have rebuttal questions. I don't know if you want me to handle that and then, or
I'm okay with arguing probable cause and then moving on if you want to.
I just have some questions,
Go ahead.
just clarifying questions.
Yeah, go ahead.
Thanks. Officer Sensei, you said you just had brief contact initially with Mr. Lowry,
Yes, ma'am.
and your concern was about Miss Melton at that time, correct?
Yes.
And when someone alleges that they're a victim of a crime, do you weigh their credibility before you investigate, or as a police officer, do you investigate?
We investigate.
And isn't it true that when you asked the defendant, had he broken into the house, he in fact told you that he did force his way into the back door?
Yes, ma'am.
And in general, when you smell intoxicants, do you find that they're more concentrated in a place like a cab of a vehicle as opposed to open air?
Yes, ma'am.
I have no other questions.
Mr. Mays? You follow?
Yeah, thank you. Just so it's clear, when you finally did detect this odor of intoxicants, quote unquote, you've been trained that the odor of alcohol doesn't actually have practically any odor, correct?
The alcohol doesn't have any odor.
Alcohol has almost no odor, as opposed to an alcoholic beverage or what you call an intoxicant, correct?
Yes, sir.
Okay. You couldn't tell if, when you detect the odor of intoxicants, you can't tell if a person has drank wine or beer or liquor, correct?
No, sir. I can't.
Okay, all right. All that you can say is I detected this odor of an alcoholic beverage around this person, correct?
Correct.
It's a sign of possible consumption, correct?
Correct.
Okay, and then the prosecutor was asking you, does it become more concentrated inside the car? I mean, Mr. Lowry literally walked out away from you all, got into his car, would there be concentrated vapors inside of his car?
Could you repeat that question?
Would there be time? I mean, was he even in his car long enough so that there would be concentrated vapors of alcoholic beverages in his car? I mean, here, let me make it simpler. Are you alleging that the odor of intoxicants spontaneously just was there once the focus of your investigation changed?
I'm not sure that's how they can just spontaneously be there. I'm not really following you.
After spending 45 minutes around Mr. Lowry, you watched him walk out to his car,
Mhm.
and then you wanted him to do a preliminary breath test because of these allegations made by the person that you couldn't get under control, right?
Yes, sir, by the allegations and
And that's where it went too straight was, so if it was consent contact, in other words, if you just wanted to follow up with a few additional questions, if he wasn't being stopped formally, you claimed you detected this odor of an intoxicant, right?
correct.
And immediately went from there to a preliminary breath test, correct?
I'm going to object. It wasn't this officer.
Oh, it was a different officer?
It was.
Oh, okay. Oh, no.
It's a horse with a different color.
It's all dark. I can't tell one person from the next. So you didn't have the face-to-face contact with Mr. Lowry in the vehicle then?
I did.
There were
did.
2 at the door.
Who was the other person that was there at the door?
Sergeant Hickman.
Who was in the hall.
Okay. All right. So what, were you working backup at that point, or did you do the field sobrieties?
I did, yes.
You did the field sobrieties.
Yes. Sergeant Hickman just mentioned while he was standing next to me while we were speaking with Mr. Lowry, he mentioned he asked him for a PBT test.
Gotcha. Okay. Okay.
At that point, he refused, and we conducted our SFSTs on Mr. Lowry.
And that's when he was ordered out of the vehicle.
Yes, sir.
So at that point, we can agree that he is stopped at that point, correct?
Correct.
And that stop is premised entirely, well, let me back up. You didn't stop him for any civil infractions, equipment violations, or any of the traditional things that we might see in phase 1 DWI detection of the standardized field sobriety test, correct?
No, sir. A traffic stop was not
Right.
initiated.
This was entirely premised on the allegations by Ms. Melton, right?
That is correct.
And so you made voluntary contact with Mr. Lowry, detected the odor of an intoxicant, which may indicate consumption of alcohol. And based upon that, he was stopped, right?
Yes, sir.
Okay. We can agree at that point right there that there's no doubt he has been stopped. He is no longer free to leave.
Correct.
Just moments before you approached his vehicle, you're saying that he was free to leave. Yes? No?
At that point, there was no accusations being made. I wasn't investigating an OWI at that point.
No, I mean, Ms. Melton is screaming out, he's intoxicated. He broke into my house. Is he free to leave at that point?
At that point, no.
Okay, all right. So he was stopped at that point?
Yeah.
Okay. And you approached the vehicle, and that's when you detected the odor of an intoxicant on his breath, or potentially on his breath.
Yes, sir.
All right, thank you.
Anything else?
I have no questions.
So my argument, judges, is 45 minutes of personal contact, which no doubt is completely consensual. But you would think that during those 45 minutes, the officer would be able to develop some type of reasonable suspicion that doesn't hinge on the credibility of somebody who doesn't have credibility, who hasn't had any contact with Mr. Lowry, who's been closed up behind this door the entire time, is threatening officers and that sort of thing. So the question then becomes, did they stop him, or did it continue to be consensual contact? And we know that at some point there, whether it's approaching the vehicle because she's screaming, or at the moment that he detects the odor of an intoxicant, at that point he stopped. So lights on or not, he stopped, he's no longer free to leave. So
let me stop you. I think it's pretty clear from the officer's testimony that the stop, and I hate that phrase because when you hear stop, you think traffic stop. Before he got to the car and could smell the odor of intoxicants, the officer thought Mr. Lowry was stopped because I have to investigate this alleged break-in. That's the way I understood your testimony. If I misstated, please correct.
That's correct.
All right, so let's start from that premise. He stopped before his nose gets into gear.
okay, so there's no evidence of a break-in, and there's no credibility to the person that they're investigating. So I think it's the case that I was focusing on was People versus Pagano, the 911 caller that makes no allegations of intoxication or any specific allegations that would substantiate what they reported. In other words, we have a person who appears to be a crazy person who's acting irrationally. Just because that crazy irrational person makes an allegation by pointing at someone doesn't give cause to stop that person. We have to weigh, like under Illinois v. Gates, I guess, we have to weigh the totality of the circumstances and look at that person who we're having a really tough time dealing with in terms of even getting her to even open the door and stop threatening us, you know, so.
Response?
This is a classic investigatory stop. The homeowner made an allegation that the defendant had broken into her house, that he was intoxicated. The defendant, in fact, admitted that he had broken into the house. While he didn't admit that he was intoxicated, the officer testified that he smelled of alcohol. Even though he previously had several contact or brief contact with the defendant prior to, at this time, his investigation became an OWI investigation. According to People vs. Rizzo, they concluded that an odor of intoxicant standing alone is sufficient to provide police officer with reasonable, articulable, and particular suspicion that the motorist had consumed intoxicating liquor. And that began the OWI investigation. I think it's very clear that he had a reasonable and articulable suspicion that the defendant had consumed intoxicants. Whether or not he admitted to it, not everybody does. We see that out every day. But in this particular case, the officer was doing his job by doing an investigatory stop, and that shifted from the stop. Well, the investigation itself began as a welfare check, and then turned into an investigation as to these allegations of breaking and entering and intoxication. Then it shifted again into operating while intoxicated because the defendant was operating his vehicle at the time and he smelled intoxicants. I think there was more than enough probable cause to for the investigation.
And I disagree under Rizzo. Rizzo is a traffic stop. Rizzo is where the officer has just moments to decide, hey, am I going to briefly detain this motorist to determine whether or not to confirm or dispel that this person may have consumed too much. In this instance, the officers are with Mr. Lowry, whether it's this officer or jointly all officers are with him for 45 minutes or more. They have plenty of opportunities to determine this man's not intoxicated. There's no reason to even pause. There's no reason to stop him from going to his vehicle. There's no reason to investigate him for any crime. They do this complete and thorough investigation there at the house, and then entirely based upon Ms. Melton's statements and screaming these statements, not just in a normal tone, but basically to try to hurt Mr. Lowry. They know that these statements are not credible.
They don't know that, Mr. Mates. It's unfair for you to say that.
Well, then they need to.
They don't know that because you'd be out of business if we just let them make all the decisions in the street.
Well, yeah, they need to.
He would be derelict. He would be derelict in his duty if he would not approach Mr. Lowry after somebody said he just broke his way into my house. He should at least talk to Mr. Lowry. Oh, just because, mentally ill people can be victims. Just because she's been unreasonable with them for 45 minutes.
Yes.
And at the last minute, she says, and by the way, the no good SOB broke into my house. I would be upset if they didn't approach him and say, what she said, she broke into the house. And he said, yeah, my son opened the door and I forced my way in, or whatever he said.
They could have said, they could have asked those questions, and I'm sure that they did ask those questions if we talked to all the officers.
He did. He testified that the questions were asked.
During the 45 minutes that everybody was there.
No,
wait
because
instead.
until the 45 minutes was up, there was no allegation that he broke his way in.
Right, so there's no basis to believe that he broke in during the entire 45 minutes either. So they know that he's not intoxicated.
Well, Mr. Mays,
They know that he didn't
hold
break
on,
in.
that's circular reasoning. There's no reason to think any crime's been committed until somebody suggests there has been.
This should be treated as if it were a 911 call, where we know that the person who's calling has no information whatsoever. None. It's nothing more than a naked allegation and has not described any specific conduct that would describe impairment or intoxication.
But you're mixing apples and pork chops. The initial stop was to see if this guy broke into the house. That's what he said. I stopped him before my nose got into gear. I stopped in his head. Mr. Lowry was stopped after she said he broke into the house. When he approached the vehicle and at that point noticed the odor of intoxicants is when his focus became a mix breaking and entering and OWI possible investigation.
He's instructed to leave. So he gets into his car, and as he's pulling out, Ms. Melton starts screaming that he broke into the house and was intoxicated.
Right, and this officer's testimony was, as he approached Mr. Lowry getting ready to leave, as he approached him, in his mind, he was stopped. Because I want to ask him a question.
Let me ask some follow-up questions.
Please do.
So she comes out and she's screaming that he broke into the house and he's intoxicated. After he's been told to leave, right?
Yes, sir.
Okay.
I didn't, for the record, I didn't tell Mr. Lowry to leave or anything like that. I don't know if any other officers told him to leave, but I did not tell him Mr. Lowry.
But certainly at that point, none of you cared if he left.
No, at that point, there was no crime.
So you are stopping him because of the allegation of the break-in, or you were stopping him because of the allegation of the drunkenness?
Both. She was screaming.
Tell me what evidence that you saw that he had broken into the home.
Well, the house was in disarray. On my body camera footage, you can see when we walk around, there's objects thrown everywhere. There's stuff broken.
Which is consistent with her breaking things. And all three statements by all three people that she was out of her mind and breaking stuff and was suicidal or homicidal, correct?
She was breaking stuff, but no statements were made that she was suicidal at that time.
Okay. Was there any evidence that you saw that Mr. Lowry broke into the house?
Other than the stuff being in disarray? No, sir.
Okay. And again, you had 45 minutes to investigate this before he was leaving, correct?
Investigate what? Clarify that.
To investigate whether or not he'd broken into the house.
There had been no allegation that there was a break-in, so why would he investigate that?
Okay, fair. So,
They're there for a welfare check.
okay.
45 minutes on a welfare check. It's only at the 46th minute that it became a possible investigation for something else.
So you believe that you had a reasonable and articulable suspicion that he had broken into the house when you stopped him?
Heather made the statement that he broke into her house and he was drinking. That's why I approached the car to investigate more.
Well, she didn't say that he was drinking. She said that he was intoxicated.
Intoxicated, correct.
And with no details of either allegation, correct?
With no further details.
Right.
Correct.
Okay. You believe that that gave you a reasonable and articulable suspicion that he had broken into the house and was intoxicated.
At that point, sir, I do have to conduct my investigation. If he
do have to. No, you don't have to do anything. You're not obligated to do anything. What would you mean that you are obligated to do that?
If somebody's stating that an individual broke into their house, I would conduct my investigation. If I chose to ignore that, and he did break into the house, we have a victim now that did not have justice because I didn't investigate.
Okay. Oh, you have a victim who you've never even made face-to-face contact with, correct? I mean, I don't want to be overly critical of this, but if she had killed herself or killed somebody else after you guys left, if you hadn't made any contact with her, well, she's threatening officers with weapons. You found that to be credible when she said he broke into my house, even though you hadn't shared more than a word with her, and not even a word with her face to face. right?
That is correct. She made statements that he
Okay.
broke.
So
into
if
my
somebody
house.
says something, doesn't matter if they're crazy, that mandates that you follow your duties and stop the person. Correct?
Correct. I mean, with all due respect, can I say something real quick?
Nope.
Nope.
So the very first thing that you do to investigate whether or not Mr. Lowry has broken into the house, just so it's clear, you or your partner demand a PBT. Correct?
No, the first thing they do is say, did you break into the house? And he said, yeah, I was let in and I forced my way in. The first thing they did in the investigation is ask a question. I was listening to the answers of the questions you asked.
I don't believe that that's what happened.
That's what he said.
Okay, hold on.
She said you broke into the house. What happened? My son was here and I forced my way in.
Can we zoom up the video?
I don't know if we can or not. I don't have the video loaded anywhere.
I've got the video. I just need to zoom into play.
Yeah.
The zoom's on. Yeah, zoom's on.
Yeah.
What's the ID? One,
Yeah.
I one.
975
You all right?
6074.
What's on top of your MCLs, Mr. Vance? What's on top of your MCLs? Big black thing up there. Is that part of his info?
Oh, a sword?
I
Is that what
think
this-
if it's easier.
Let's find out. He's trying to do a screen share.
No, I'm totally good. I was just coming to their aid and
If
stuff
you
like
want,
that.
if you think so, then handle it that way.
Well, I gotta be, sure that you're good to drive. I can't have you driving and you've been drinking all day.
My
Oh.
dad.
If that's the case, you guys can just swap seats,
I didn't get off work till 4 o'clock.
I didn't hear you, Bailey.
I'm fine.
Bring it out.
That's just one of them.
Can you back it up, Mr. Vance?
Let's start the video.
For sure. But and from my point of view is that she'll come up to my station and make a complaint if we don't.
It don't matter.
Oh, it matters when my boss asks me a question. That's why. You know what I'm saying? I can't
Yes, sir.
just.
I was involved in a car accident when I was drunk driving back in 2000.
I'm familiar with you. I know.
I would not be in this car right now if he was.
Yeah.
So that's my son. I would
Okay.
not be in this car.
Okay.
Do you have a valid driver's license?
He doesn't.
You don't?
He's got a state ID. She's got a good driver's license.
All right. Well, I'm gonna give you a breath test, okay?
Okay.
So just hang tight.
No, if it's over, you're gonna have to have more than
Just a breath test.
handle it as a straight OWI.
Right now.
All right, what do you want me to do?
Step out the car real quick.
You want me to pull back in the driveway?
No, just leave the car. So you had nothing to drink today at all?
I had a 20.
I think we're well past the end of the reason for the stop, aren't we?
How long ago?
Yeah.
That was 3 hours ago. At least 3 hours.
Just one?
Hey, I don't need to hear you from the street, okay? You can go inside and I'll talk to you in a minute. I got it.
Just step back this way.
If you know which one leads up to that, I'm more than happy to play it.
It might just be Sergeant Pittman's. That's who was with him at the time.
Okay. And was that your body cam that we were watching?
Display case.
That one, yes. I did.
So just so it's clear, we didn't have everything there, but there wasn't one question that you asked him about breaking into the house, correct?
It's prior, before that video, there was.
Okay.
You could see me walk up to the car and ask him about the alleged break-in that Heather was stating.
Okay, let's see if we can't find that.
You need to buy an iPad. It's got a bigger screen.
It's because of that 35th district.
What, they took your iPad?
Sorry, no, I had a client that wouldn't make up her mind on what to do, and so we sat there for 2 hours. And so I couldn't go back to the office to grab,
Oh, I got you. I
yeah,
got you.
so I had to rush right here.
You got a bigger screen.
Well, it wasn't just a client, it was also that Judge Plakas had a restitution hearing over some guy that had broke a window, over how much the window cost, a bell tire or something like that. And I was telling the prosecutor, I was trying to, I was looking for an ice pick, but
Right.
couldn't find one. Maybe it's easier if you play your video. I'm gonna hunt through these videos, I apologize. But that's where my video starts, the primary in car.
My laptop
For the
is
primary.
on disc, so I don't know if there's a way to play it.
You're asking the wrong person.
You want to give us 5 minutes, Judge? I
No.
can figure out which ones this
Go
is.
ahead. Go ahead.
Thanks, let me walk. We want to just take a break?
Yeah, go ahead.
All right,
Do
thank
you have
you.
anything else about it?
No, I just want to step up.
Too much pressure with me watching.
Officer, good.
Take a break if you want.
I know.
That's a really smart idea.
Hey. Close it. So the escort got all straightened out, or? Right. Right. You don't have the paperwork, says he owns it. Right. Right. Yeah. Good. He's pretty excited about it. Good. Yeah, good. Kids have a new house for Christmas. We should have just sent him to his office for his iPad.
So Judge, what I've got is axon body number 2 that ends in 975. That one, the file number 0044 or N0044.mp4 doesn't show me what you're talking about. And what I've got labeled, I've renamed it as primary video on the case, which also ends 975 on the body cam. Where it starts is where I started playing it.
Hey, let me just, we're about to.
Oh wait, maybe I'm wrong. Hold on.
You get that on record.
Oh.
Starts with officers talking and then approaching.
Yes, you're right. Hold on, I don't have volume. No, it's too far.
I have it set up now.
Okay, go ahead.
Do you have the HDMI cord?
Yes.
Maybe it'll work this time. Sorry.
Is that me?
I don't know.
You should keep that. Oh, then why do you go? No, he left. I think he went to Best Buy.
Just from my point of view is that
Okay. I don't know. Was it faster? Yeah, that sounds like it's on. What's the case? She's got her own. I wondered where you were going.
I'm glad you guys stopped me. I tripped 3 times.
You tripped.
Well, you, get an A, you get an A for effort. Oh, I wish I'm gonna go review cameras.
Okay.
I know, I wanted to see you running. Want to come up here?
Yeah, do I have to turn this on for it to work?
I don't know.
Is it part of it? I mean, alternatively, I can just play through the Zoom still.
Well, we're really after the audio more than the video anyhow.
Sorry, oh, yeah. So I
So,
just,
turn the
play it out.
volume up.
all right, I can do that.
You know, Mr. Mays and I can stand behind you and watch what's going on.
Do you have me to?
Maybe they can plug it in. Yeah, try
Put it right there and then put the
Yeah, try it.
mic.
Mr. Mays, if you want to watch it up here.
Turn up the volume on this too.
I just want to make sure. Don't live here, right? She lives on her own.
No. My son and daughter live here. We're separated right now. And, but my house is still, my name is still on the house.
Okay.
And,
Did you let him in the house? Okay. All right, man.
well.
I just want to, if she wants to talk, to us, I just want to smooth everything over. If she doesn't, then that's it.
She's gonna be all right. She's gonna try to, say different things, like, I don't know you were okay. Which I did force my way into the back door, just worrying about her well-being. That's it. I mean, that was going, but she was still okay and stuff. So,
But your son let you in
yes.
initially. Okay. Yeah. All right. You had anything to drink tonight?
No, actually, I was at home having a bowl of cereal, a couple pieces of toast, when they called me to come here because she was being irate. And,
Well, I just want to make sure you're good to drive. I smell a little bit of alcohol coming off you, man. Take a PBT?
what's that?
You'll take a PBT?
Or what? What's that? I don't need that. No, I'm totally good. I was just coming to.
Could I recall the officer?
Sure.
Thanks.
Still under oath, officer.
As you approach the vehicle, you started, and I apologize for my earlier questions. You approached the vehicle. That was you that we heard on the audio just now?
That was me and Sergeant Hickman.
Okay. And you were asking what the marital situation is between these two, correct?
And I asked him if he lived there, Officer
Right.
Hickman asked him about the marital situation.
And you were able to ascertain that he actually owns that property. Correct?
He stated he does not live there.
You were able to ascertain that he owns that property, correct?
When I asked him if he lived there, he stated he does not live there.
Let me rephrase the question so you understand.
Sure.
You were able to ascertain that he owns that property, correct?
No,
He said to you point blank, I own that house, right? We just heard
okay. I mean, to me, he said he didn't live there.
it. Okay. He owns it, correct?
Correct.
Okay. And so the allegation that he's breaking into the house for some sort of felony, this investigation, I mean, it doesn't even matter. He owns it. It's his house. Right?
Correct.
Okay. And that's when you then asked about the odor of intoxicants, correct?
While I was speaking with him, yes, sir.
Okay. Now, just so that we're clear, a few minutes before this, you and the other officers were walking down the driveway away from the house, correct?
Correct.
And that was when you and the other officers were discussing the fact that you would have to go stop Mr. Lowry because otherwise she might complain about you guys, right?
That's what one of the officers mentioned on scene.
Okay. And so did any of these officers that were on the scene I mean, working jointly together, of course, did you ever develop probable cause or reasonable suspicion to believe that she was a credible witness or that she was a credible complainant that you know of?
That was my first time dealing with her, so I have no prior experience.
What about the other officers? Did anybody else have more experience with her there?
I'm not sure. I believe Sergeant Hickman had prior runs with her, but that was my first time dealing with her.
Thank you very much. No further questions.
I have no questions.
Okay, you can sit down. Back to argument.
Again, Judge, I think that he's being stopped unlawfully. I mean, my real problem with this case, Judge, is they do this very incomplete investigation where they're there for 45 minutes and accomplish nothing in terms of determining whether or not this Ms. Melton was safe, you know? So let's just take Mr. Lowry's words at his own, at face value, that he broke into the back door after his kids were already there. Now his kids are calling, they're both adults. They're calling him to come onto the scene because she's out of control, she's crazy, she might hurt herself. And they force their way into the house. He owns the house, he's allowed to force his way into the house. Number one. Number two, it would be an emergency. And meanwhile, they're all dialing 911 and getting the police out there to help her. The police respond to the scene, and it's not like she just clears it all up. It was a big misunderstanding. To the contrary, she tells the officers, I have weapons in here with me. I'm going to hurt you all. Leave me alone and leave. And they do. I've never heard of such a thing where they leave because they've got a person there who's obviously dangerous. Maybe she's messed up. Maybe she's drunk. Maybe they're just decided that it's best to let her sleep it off. I don't know. But for her then to launch into allegations against Mr. Lowry, it doesn't matter what the allegations are at that point. She has no credibility whatsoever. And these officers have to make that determination, just like they do with other determinations when they're working out there in the field. What is the credibility of this person? Should I go and act upon this person's information? And the answer is no, you don't act on that person. To the contrary, that person, they should have taken her into custody and either taken her into jail or taken her in for involuntary commitment proceedings. Because like the officer said, the house was destroyed by her. The house was literally destroyed and for no reason whatsoever. So, I mean, whether I don't know, that's my argument, is that they don't get to launch into a different investigation just upon the say-so of this person that they're not doing a complete and thorough investigation about, who's clearly mentally not competent or whatever the word is. Thanks.
You're welcome.
Counsel is very hung up on whether or not the individual who made the claim, the victim in the matter, for purpose of the second investigation, was credible. The officer is an officer, he's a police officer. He gets to somebody makes a claim, somebody makes an allegation of some crime, and he investigates. he doesn't sit there and be like, well, let's look at her back history, check to see how many calls she called 911, how many times have we come to the scene. He investigated the claim. In fact, the defendant agreed that he did kick through the door, and then the officer smelled alcohol. Initially, well, after he eventually gets out of his vehicle, he does admit to consuming alcohol. And then we go through the OWI investigation. There was certainly enough probable cause for him to make the investigatory stop for the purpose of.
Thank you both. I'm not going to put the officer on the spot by asking him, but I'm pretty convinced that when these officers approached Mr. Lowry after she started screaming her allegations, their mindset probably was, let's just talk to him so we get her off our back and we'll send him on his way. I doubt very much if they thought there was any kind of crime whatsoever that Mr. Lowry had committed. But once, and you know what, officer, I'll give you the benefit of the doubt. I don't think the odor of intoxicating beverages suddenly materialized. I think once somebody started talking about intoxication, your brain probably kicked into that mode, just like it does when you stop what you think is a drunk driver. Your brain's in that mode when you walk up to the car. So you're going to be more attuned to smelling what you expect to smell if there's a drunk driver you're dealing with. When you're dealing with you don't know what, and somebody's locked in a bathroom, I don't think your brain would be engaged that way. And I think once you smell the odor of intoxicants, I think that's probable cause to take it the next step. Yeah, I mean, it's an unfortunate situation for Mr. Lowry. He showed up to do, the right thing to make sure his wife was okay. But I think there's probable cause for the investigation for an OWI. Can you accomplish anything today?
No, the second part of this motion is probable cause, because I allege that Mr. Lowry passed all the tests after they made contact.
Okay.
So I don't know if they want to present him. I'm not sure exactly who's doing the FSTs. I'll be honest with you.
What's the next step? Who's a witness for that?
Officer Tom.
Come back up. You're still under oath.
All right, we're going to pick up where we left off. Did you ask the defendant to step out of the vehicle?
Yes, ma'am.
And did the defendant step from the vehicle?
Yes.
Did he say anything to you?
I asked him if he consumed any alcoholic beverages, and he stated he consumed a 24-ounce Corona.
Are you trained to get field sobriety tests?
Yes, ma'am.
And what kind of things are you observing when you conduct field sobriety tests?
The HGN test. I observed the smooth pursuit, 45 degrees, nystagmus, and nystagmus at maximum deviation in that test. The walk and turn test. I observed 8 indicators in that test. And I performed the one-leg stand test.
All right, let's talk a little bit about the walk and turn test. Did he follow your instructions?
No, ma'am.
How did he follow? Well, how did he perform?
Well, I advised him to remain in the starting position. I believe he started earlier.
Do you need your test to
I'm sorry.
refresh your recollection? Do you need your
Yes, ma'am.
report? There you go.
And we're focused on the walk and turn.
I'm just gonna have you read it to yourself, and then
Okay.
when you're done, refresh it. Good, all right. How did he perform on the walk and turn test?
The arrestee did not walk heel to toe. He did step off line several times throughout the test, and he took the incorrect number of steps. He also did not count his steps out loud at the beginning of the test.
And how about, what was the next test?
The HGN test.
That was the first test.
Oh, the next test after that was the one leg stand.
How did he perform? Did he follow your instructions?
He followed my instructions, but he was unable to perform the test. He placed his foot down numerous times throughout the test, and I eventually stopped the test.
Did you stop the test for safety?
I wouldn't say for his safety. I just I didn't see a need to prolong for that 30 seconds of span of time when he was already showing indicators that he could not perform the test, so I stopped him.
All right, and what was the next test?
I provided him one more test, which would be the number test. I just asked the defendant to pick a number between 25 and 27. He picked the number 26.
Good. Overall, how would you say the defendant performed on these tests?
He did show some indicators of signs of intoxication when it comes to my instructions that were given, his performance on the walk and turn and the HGN test.
So what kind of things were you looking for?
On the HGN specifically, I'm looking at smooth pursuit in both the left and the right eye. I'm looking for nystagmus at 45 degrees and nystagmus at maximum deviation in both the left and the right eye.
And for the other test, what are you looking for?
The other test I'm looking for, if the defendant starts the test early, if he follows my instructions, does he take the right amount of steps? Does he keep his arms down by his sides? Does he count his steps out loud? Is he walking heel to toe while he's performing the test?
And did you, oh, sorry, Jen.
That's it, sorry.
All right, did you smell intoxicants on the defendant's breath during this time?
When I initially approached the vehicle and I was speaking with him, yes.
How about like during the HGN when you're close to him?
The HGN, no.
Okay. And how often, well, is there anything else that you observed or anything else that happened regarding the defendant that I may not have asked you about as it relates to the field sobrieties?
No.
No. How often have you come into contact with people who are intoxicated?
Quite frequently, probably on a daily basis.
When typically would these contacts occur?
On calls.
And based on all of your contacts, do you think you are able to identify an intoxicated person?
Yes, ma'am.
On the basis of your experience as a police officer, did you form an opinion as to the intoxication of the defendant?
Yes, ma'am.
What was that opinion?
Well, he was definitely showing signs of intoxication during my tests, and I made my determination from that.
All right, and you're a certified portable breath test operator?
Yes, ma'am.
Did you advise the defendant of his rights as it relates to providing a sample?
Yes, ma'am.
And did he consent?
Yes, ma'am.
And what are those results?
0.13.
And at this time, did you place the defendant under arrest?
Yes, ma'am.
Do you want me to continue or?
Let's see if Mr. Mays has anything at this point.
Certainly.
Any questions?
Sure,
Come on.
thank you. So let's talk about the HGN test. There's a certain procedure for doing the HGN test.
Yes, sir.
And what is that procedure?
If the individual is wearing glasses, you advise them to take off the glasses for the HGN test.
Okay.
I did not advise Mr. Laurie to take off his glasses.
I asked you how the test is being
Okay.
done. I didn't ask you to explain what you did wrong.
Okay. So if somebody is wearing glasses, have them take it off. Have them stand heel to toe, hands on by their sides, eyes looking forward. Advise them on the instructions to follow the stimulus. I would put it approximately 12 to 15 inches from the individual's face.
Okay,
Advise them or ask them if they can see the stimulus, have them touch it, and then advise them to follow the stimulus with their eyes only without moving their head. At that point, I would do 2 passes to see if he has equal tracking in both eyes.
okay,
No resting nystagmus. I will then go into my nystagmus at 45 degrees. This is when I leave a little bit of a white on the side of the eye. You can see the involuntary jerking. And I would do that in the right eye for about 4 to 6 seconds, and then back over to the other eye for 4 to 6 seconds. And then I would go into the maximum deviation, which you can't see any white in the eye.
okay,
And I would hold that for about 4 to 6 seconds in one eye and 4 to 6 seconds in the other eye.
okay.
For
Is that it?
test. For the HGN?
Yeah,
Yes.
all right.
I didn't conduct the, I know you can do the vertical nystagmus, but I did not perform that.
Well, it's part of the test, right?
Correct.
Okay.
I just didn't perform.
So when I asked you if that was it, after you're done doing all that horizontal movements, then you do vertical movements, correct? For vertical gaze nystagmus.
Correct.
Okay.
That
And
was
we can agree that number one, you didn't follow the proper procedures, correct?
correct.
And number two, what you just described is not how the HGN test is supposed to be conducted, correct?
Correct.
Okay. We can agree that everyone exhibits naturally occurring nystagmus, correct?
Correct.
And the prosecutor asked you on direct examination if he showed signs of intoxication during this testing, right? And really, you're not looking for signs of intoxication. You're looking for clues, correct?
Correct.
Okay.
Just for my edification, what's the difference between a sign and a clue?
Officer, you were trained that the standardized field sobriety test battery is based upon statistical analysis, correct?
Correct.
And that this is subject to these validation studies in San Diego, Florida, and Colorado, correct?
Correct.
And so it's not your job to come to an opinion as to whether or not a person is intoxicated. It's your job to administer the test properly, score the clues properly, and interpret the subject's performance based upon those clues, correct?
Correct.
Okay. So when the prosecutor asked you, do you have experience judging intoxicated people? I might have experience judging intoxicated people. You might have experience in judging intoxicated people, and a bartender might have experience too. We're only concerned about the proper administration of these tests and the clues that are affiliated with that test and assessing the subject's performance based upon those clues, correct?
Correct.
Okay. You were trained that certain people are not capable of being properly, well, just wrapping up with HGN so that it's clear for the court. The proper way to do the test is to do 2 passes for equal tracking, correct?
Correct.
After you've had the subject remove their glasses, right?
That's before having them removed.
Right. And you said you did not have him remove his glasses,
I
correct?
did not, sir, no.
Did you do the other preliminary medical checks? There's 3 total preliminary medical checks, correct?
Correct.
Okay. Did you check for the other 2?
I checked for equal tracking and resting nystagmus.
Okay.
That's all I checked for.
All right. And so that would mean that as you sit here today, you don't recall the 3rd medical check, which is to check for equal pupil size, correct?
Correct.
Okay. And then after checking for equal tracking, you then go into the lack of smooth pursuit, correct? Yes?
Correct.
And that requires you to move the stimulus at a certain rate of speed and over again, and then repeat that process, right?
Correct.
Not 45, correct?
Correct.
All right. So after lack of smooth pursuit, you then go into the distinct and sustained nystagmus at maximum deviation, right?
After 45 degrees, I went into the sustained maximum deviation.
Preliminary medical checks, lack of smooth pursuit, Distinct and sustained nystagmus at max. 45 years. Yes?
Correct. That's not how I performed it though.
No, I'm not asking how you did perform it. I'm asking that's the way that you're supposed to perform it.
Correct.
Okay, you didn't do it that way.
No.
Okay. Now, walk and turn, there's specific instructions for the walk and turn, correct?
Correct.
Let's start though with the fact that certain people cannot pass the walk and turn, correct?
Correct.
You're told about people with back, leg, and middle ear issues, correct?
Correct.
They cannot do the test, right? Somebody who's, I think, 65 years of age or older, correct?
Correct.
Correct or incorrect? I can't
That's
tell.
correct.
He's saying correct.
Oh, okay. Okay. And according to the Journal of America, the Journal of the American Medical Association, August 2023 study regarding the use of the standardized field sobriety test act on marijuana-induced drivers, they found that 88% of completely sober motorists fail to walk and turn with 2 or more clues, correct? If you know.
I'm uncertain.
Okay. Did you ask Mr. Lowry the requisite questions necessary before administering the walk and turn?
At one point, I did ask him if he had any medical issues with his knees or anything with his legs bugging him. I'm not sure if that was before the walk and turn test or not, or if that was before the one leg stand.
Okay, all right. The way that Mr. Lowry performed the walk and turn would be consistent with a person of his age, his physical demeanor, and his physical limitations, correct?
That is incorrect. I mean, he didn't follow the instructions that were given to him. He didn't count his steps out loud. He didn't take the right number of steps as far as him stepping offline. And you're saying his limitations based on his age. I don't think following basic instructions has a limitation on one's age and how they can follow instructions given to them on a certain test.
Well, one of the important factors for the walk and turn is to not interrupt the subject's performance of the test while it's being conducted, correct?
Correct.
And don't we have Ms. Melton screaming in the background the entire time?
I believe that was when I was conducting the HGN test. That's why she was distracting me as well when I was doing that. That's why I didn't.
Right, right.
As far as when he was performing the walk and turn, I'm not sure if she still continued screaming at that point or not.
Okay. And the one leg stand, you're saying that the one leg stand, you didn't have clues on that one, but you stopped the test.
He placed his leg down multiple times throughout the test, and I ended up stopping the test.
Okay, all right. Now, let me back up. I asked you earlier all those questions at this culmination of the stop. One of the initial questions you asked him to do, or one of your fellow officers asked him to do, was to submit to a preliminary breath test, correct?
Correct.
Okay. And that was before you asked him to exit the vehicle, correct?
That's correct.
And then he was ordered to exit the vehicle, correct?
Correct.
Okay. Now, why was he ordered to exit the vehicle?
At that point, I was handling it as an OWI investigation.
Fair enough. But we can agree that he was ordered to exit that vehicle, correct?
Yes, sir.
Now, you understand that you are almost universally allowed to order a subject to exit the vehicle for officer safety, correct?
Correct.
There was clearly no concern about officer safety because Mr. Lowry had been in your presence for almost 45 minutes to an hour, right?
That's correct.
Okay. So you weren't ordering him to exit the vehicle for officer safety, correct?
At that point, no.
You were ordering him to exit the vehicle so that he would be compelled to perform field sobriety test, correct?
Correct.
Okay. Did you indicate to him? Oh, I'm sorry, let me back up. We can agree that the preliminary breath test that was offered to him prior to the exit order, that would constitute as a search, correct? Requesting a person to submit to a PBT is a search, correct?
Correct.
And that is the reason why you ordered him to exit the vehicle, correct?
No, I ordered him to exit the vehicle because at that point I was going to conduct an OWI investigation.
Those tests are completely voluntary, correct?
They are.
HGM, walk and turn, and one leg stand are all voluntary, right?
Yes, sir.
Did you explain that to Mr. Lowry?
I did not know.
So you ordered him to exit the vehicle and he had no choice about that, correct?
Correct.
Okay. After ordering him to exit the vehicle and not for officer safety, you then ordered him to perform these tests, correct?
I told him I was going to put him through tests and he said he performed them. I don't know if I ordered him or not, but I did tell him to conduct these tests.
It was never made optional for him, correct?
I know I didn't give him the no.
And then after going through all that, you then did this preliminary breath test afterwards, right?
Correct.
So an attempted search followed by an exit command, followed by these field sobriety tests, followed by another search, correct?
By search, you mean the breath test?
Yeah.
Yes, sir.
Okay. All right. And then you arrested him and asked him to submit to a blood draw.
Yes, sir.
Why did you ask for a blood draw?
We don't have a data master machine at the station, so you go to the Henry Ford to get blood draws.
There was no machine at that time, or there's
At
no?
that time.
You've got one now.
We have one now, yes, sir.
Okay. All right. Did you ask him if he was diabetic before you?
I don't believe I did ask him that, no.
Okay. You understand that you're supposed to advise a person who is diabetic or a hemophiliac that they don't consent to blood.
Yes, sir.
All right. Thank you very much. No further questions.
Any questions?
I have no question.
You can step down. Again. Any other witnesses?
I don't have none.
Argument.
I'm good, Judge. I think that they've established at least enough. I would ask that the court suppress the HGN test, though, based upon the officer's testimony today for further purposes. But I think that the rest of it kind of goes forward.
No objection.
Granted.
Thank you, Judge.
Anything else?
No.
Take some time pre-trial?
No, we can't.
I already made an offer.
We are forced
No, it's all
to
right.
go to trial.
All
So
right, do we have a date? Have we done that yet?
what's that?
Have we had a date picked yet?
No, if you want to, we can.
Come on up.
Let me go grab mine.
Yeah, go ahead.
I've been going since 6:30 this morning. I got a discovery packet at 9 a.m. in Novi. So I had to get into the office at 6:30, start watching videos. And these in-person videos, in-person in Novi, in-person in Plymouth, and then of course in-person here.
Isn't it great?
I can't go this long.
You had to sleep more.
Can't go this long.
Go to bed earlier.
I went to bed at 1.
That's what I mean. Go to bed earlier.
But that was early. I was watching Raiders of the Lost Ark, the newest one.
Oh, well, at least it was for good reason.
Oh, spectacular. I turned to my wife. She said, that wasn't too bad. I should probably watch the originals. I said, wait, what? Oh, no. I said, how did we even get married?
We're not best friends.
Well, it was worse because I started playing the original at 1 a.m. saying, you gotta watch this one, right? And I caught her looking down at her laptop repeatedly. What are you doing? This is the original. Stop looking down at your computer.
What are we looking at?
You doing a jury?
Yeah. Well, I'll think about it. I'm talking.
Well, let me know soon. Though.
I will.
You know how these are hard to find.
Yeah.
That's a regular docket.
It